Well, as you know, Hlophe over the years has elicited strong reactions one way or another. Chris Oxtoby is a research consultant at Freedom Under Law. He joins us now. Chris, good afternoon to you. Your organisation has sharply criticised Hlophe in the past. How do you feel about him now, going to the Judicial Service Commission to help select judges?
Well, perhaps predictably, I think it's something we find enormously concerning. I mean, I think you've already alluded to the fact that he has himself been removed from judicial office as recently as the beginning of this year. And I think it's just worth, Stephen, dwelling on what that was about, lest we forget, is that he was removed after it was found that he had attempted to influence judges of the Constitutional Court to decide a then highly politically sensitive case involving Jacob Zuma, now the head of the MK party. So an impeachment of a judge is always serious. His impeachment was of a particularly serious misconduct. And it's really perplexing to think that we could be in a situation where somebody who has had that track record can be sitting in a position where they are assessing the suitability or otherwise of other candidates for appointment to the bench. I think it's a highly problematic development.
Is there any legal reason stopping him from going? I mean, would there be any legal basis for a challenge of some kind? I'm not aware of anything like that happening in the past, where a commissioner of the Judicial Service Commission was deemed unsuitable to serve.
Yes, it would certainly break new ground. I think the first important thing is to acknowledge that, yes, there is not a formal prohibition which states that somebody in Dr. Hlophe's position is not eligible. But I do think if we look at the Constitution more broadly, we consider provisions which, for example, put an obligation on organs of state to protect the independence and dignity of the courts. If we consider the principle of legality requiring rationality in the exercise of public power, then it may be that the decision is susceptible to challenge on those grounds. That's something that we will have to wait and see how that may play out in the future. It does point, I think, to a lacuna, and this was something that one of the speakers alluded to during the debate. There is a lacuna in that someone in his position, in the position of the former public protector, who was also removed from office, are remain eligible to go to Parliament as MPs, and that is perhaps a point that needs to be considered in the future as well. But I think the very particular circumstances of the Judicial Service Commission and the role it plays in the appointment of judges does bring these considerations very sharply into focus as far as Dr. Hlophe is concerned. So it may be that there is a challenge based on, as I say, broader provisions of the Constitution rather than an express prohibition.
When we start talking about law, and particularly when it comes to matters before the Judicial Service Commission, rights go in many different directions. I mean, Dr. Hlophe may well have, and at the moment actually does have, the right to represent his party. He's been nominated, Parliament's approved it, he has the right to be there until something changes. Someone coming before him as a commissioner, in other words, a lawyer or someone who is a candidate to be a judge, would they have the right, maybe, I mean, as strange as it may seem, to say, actually, I object to being asked questions by someone who himself has been found guilty of misconduct by the very body that is interviewing me? In other words, could someone who's being interviewed to be a judge say, the person asking me questions has himself been found unfit to be a judge?
That's a very interesting question. It's certainly, I've never seen the like of that happen in the JSC before. But then we've not seen a commissioner sitting on the JSC with this kind of background. It would certainly be a gutsy move. It would be a brave move. Someone could try it. To be honest, it's exactly the sort of thing that provides the basis for many organizations to have said that the Judicial Service Commission itself needs a code of conduct to regulate the behavior of commissioners, because it would be so unprecedented that it would have to be worked out on the fly. I think we would all hope that the situation can be resolved one way or the other before the next round of interviews, so that situation doesn't need to arise. As I said, it could be tried. I think that it would be a brave candidate, though, because if that doesn't succeed, they may be opening themselves up to some quite difficult lines of questioning. But that does, again, just provide a further illustration of why this is not an appropriate designation to the Judicial Service Commission.
What influence could Hlophe have on the Judicial Service Commission? Very difficult to predict the future, but no one can deny the man's immense knowledge of the law. He has a doctorate in it from Cambridge, of all places. At the same time, he's someone with vast experience. I mean, I would imagine someone could make a strong case to say this is exactly the kind of person you want to have coming from Parliament to be on the JSC.
I mean, that is the tragedy of it, in a sense, is that I know some of the debate has been focusing in support of him sitting on the JSC, has been emphasizing his qualifications, his experience as a judge, his PhD from Cambridge, and so on. And that is all true. And if his knowledge and experience and background stopped there, then I think there would be that might be a more persuasive case. The problem is that one simply cannot ignore the circumstances around his removal from office, as I've alluded to, and that really does set it apart. In terms of how influential he's likely to be on the Judicial Service Commission, I think it's reasonable to imagine that he would be a very serious voice who would be listened to quite strongly on that body because of that experience. Which again makes the problematic aspect of the circumstances around his removal all the more important to bear in mind.
As things stand, we sort of have two Judicial Service Commissions. But what I mean is we have the one that meets in public. We see the interviews that are conducted. That is all broadcast live, often on this channel. And then we have the sort of closed-door meetings. So in other words, they conduct the interviews. The decisions that are then made are behind closed doors. But those meetings themselves have become more and more transparent, as I understand it. Transcripts or minutes of those meetings now have to be made publicly available after those meetings. What I'm trying to get to is it becoming easier to work out what influence each commissioner has. I mean, this would apply to Hlophe, it would apply to Julius Malema, it would apply to Athol Trollip from Action SA. He's also going to go to the Judicial Service Commission. He's got no legal experience at all. He won't be the only one. What I'm trying to get to is, are we now getting to a point where we can see what influence each commissioner has on the final decision?
I'd be a bit hesitant to go that far yet. I think the first point to make is that the transcripts records of the deliberations are only become public when there has been a review decision challenging a decision by the JSC in court. So, for example, we've seen in recent years both CASAC and Freedom Under Law bringing challenges which have brought the record of deliberations for the interviews in question to light. I mean, one can infer a certain amount, I suppose, from that in terms of who's talking, who says what, how much they talk. But I think there is a lot that happens around the edges. There's discussions over tea, there's discussions during breaks, there's conversations perhaps in the bar afterwards, which I think will be quite influential as well, which we don't get to see. I think we can make reasonable inferences based on the questions that are asked, based on how commissioners interact with each other. But it's still, I would characterize it as still being a fairly opaque process in terms of who is having the most influence and in terms of what grounds the commissioners are actually making their decisions on. We hope that they're making decisions based on the criteria that the JSC has announced and developed. But it's very much an open question about whether that's actually happening. And in fact, that's been a basis for Freedom Under Law's challenge to the JSC's interviews last year. So there's a lot that we still don't see.
Chris Oxtoby, thank you, from Freedom Under Law, an organisation which in the past has opposed Dr John Hlophe.